Hey, we're back. I guess this is episode 3 now of We Are Judging You. Again, I'm George Edwards. As you can see, we have brought a guest onto the show, really our inaugural guest, Mr. Allen Zwernemann, who is an authority in some of the information that we're going to discuss today. So I'm George, this is Allen, and this is my law partner, Murtaza Sutarwalla. Today we're going to talk about the worst kept secret in America, probably from the American public, and that is, what is a civil rights case? And how do you prove it? And what are going to be some of the defenses that the government may use to defeat your case? I can say I've been practicing since 2006, so that's almost going on 20 years. This is the hardest cause of action to win that exists, and that's because it's for several reasons. And we'll go through it in a second. But if you read civil rights statutes, there are two main ones that we'll discuss today. 42 United States Code Section 1983, which governs most civil rights cases that you're going to find. Police beat downs, jailer ignores your request for reasonable medical care, jailer beat down cases, things like that. But you also have another class of cases that Murtaza is going to get into later, where you can sue companies if they impugn on a contract, express or implied, that you have with them, and they breach it. You can actually bring, and that breach is due to certain enumerated reasons, you can actually file what's called a 42 United States Code Section 1981 case. So we're going to get into that later, and that also has some like employment implications as well. But just starting from bird's eye view of what is a 1983 case. So if I say a 1983 case, I'm talking about the bird's eye view of just a general civil rights case. That we've heard of, and everyone knows about the unfortunate George Floyd events that happened in Minnesota. That is the quintessential civil rights case. What's going on there? How can you prove it if you've been assaulted or if you've been attacked or if one of your loved ones has died as a result of an encounter with law enforcement? How do you prove it? And then we'll talk about why it's so hard to win. And then we can talk about why it's so hard to get any money out of the cases. And it's all done, in my opinion, by design in a civil rights case. Okay, so basically, for a civil rights case, you've got to prove several things. Okay, you've got to prove that your rights were deprived by one who was acting under color of law. Okay, that's normally going to be law enforcement official, could be a sheriff, could be a state official. But if you can prove that a clearly established, and I put that in air quotes because that's something that the courts have created, a clearly established constitutional right has been violated, then you shall be entitled to get damages. That the statute actually says that the actor is liable, shall be liable. However, in practice, it's much, much harder to get all the way to liability. So basically, that's bird's eye view. And people ask the question, why is it so hard? Why is it so hard to win civil rights cases? Because courts have created doctrines that will defeat it. One of the big ones, which is always used in just about every civil rights case, is the doctrine of qualified immunity.
And that's for the individual officers, correct?
For the individual officers, not created by Congress, not announced by executive order, created by a court. Originally out of Mississippi, it was a state court case and then adopted by the federal Supreme Court. So now it's like almost like a federal doctrine, okay? And most officials are going to assert, hey, if you think I hurt you, I have immunity under law. Therefore, you not only can you not sue me, you damn sure can't get any money out of me as a result of your lawsuit.
Let's back up for just half a moment. Would you say that these cases arise in the context of the use of excessive force?
Yeah.
What would be an example?
Yeah, so officers can use force generally, okay? But the force cannot be excessive to the need. So if there is someone who is subject to arrest and they're being passive, they're just sitting down and they don't want to move, The officers are permitted to use force to put you inside of the police vehicle to secure you and then transport you to the jail. Okay? When you're on the street, law enforcement always wins. If you want to challenge an arrest, you have to do that later, hopefully with the help of your attorney in front of the judge. Okay? And you can beat the rap, but you're not going to beat the ride. That's the old saying. Okay? I'm an 80s baby. You can beat the rap, but you're not going to beat the ride. So that's an example of an officer using reasonable force. They lift you up, or they immobilize your hands, or they immobilize your legs for transport to a facility. Now we have the doctrine of excessive force that is clearly and objectively unreasonable, such that no reasonable officer would have employed that use of force in whatever factual situation that you're dealing with. Very high standard. No reasonable officer would have employed that force, okay? We'll take the George Floyd example, holding him down using body weight, kneeling on the neck in the face of someone pleading that they cannot breathe. That is generally held to be an excessive use of force. So yeah, there's a huge difference there.
Would it matter if they're restrained or in handcuffs?
So typically, if you're restrained in handcuffs, the officers can look at, and it's true that law enforcement has to make split-second decisions at any given scene. And we support law enforcement, generally. But however, if you are restrained, if you're in handcuffs, if you are cooperative, you've identified to the law enforcement official, you've got to identify to law enforcement officials. You don't have to tell them where you're coming from, you don't have to tell them where you're going, but you have to identify.
And I think that's an important point, because I think there's this concept that you don't have to show ID.
Oh, yeah. Yeah. And that's a big myth. You have to identify to law enforcement, and you can't lie.
Then why do you have to identify yourself to law enforcement?
Just speaking from my own personal opinion, is so they can run you through their system and find out what kind of a threat you are. Do you have any warrants on you? Do you have any tickets on you? You know, who are you? And it's also for processing reasons. If they're going to take you down and process you at JPC, which is in our county, it's Joint Processing Center downtown. It's for those reasons too. But you have to identify to the officer. But you have this idea of what is passive resistance versus what is active resistance.
And that's when you get to the point where you're in a situation where you're actually going to be arrested, right?
So if you're actually going to be arrested, okay, there are certain factors that are going to be considered. Have you tried to flee? Have you complied? Have you uttered any threats to law enforcement? Are you restrained already? If you had any weapons or anything that could harm the officer on you, is that still in proximity to you, or have they secured all of that? And it also comes down to, in some of these cases, whether you've got 5 officers at the scene, 10 versus 1 human, or 1, we'll call them suspect for purposes of this conversation. Or is it a situation where you might have a smaller female officer and you have this big brooding suspect such that one move and he could just knock her out, and just one move. You've had those situations as well. But passive resistance is essentially you are being responsive, but you're not necessarily following all the commands as fast as law enforcement thinks that you should, which is a completely subjective determination. And sometimes you cannot follow either multiple directions, which conflict with each other, or with directions that your body simply can't respond to because maybe you were hit over the head. Maybe you've just been in a car accident. Maybe you've suffered a head injury and you have a TBI, which is traumatic brain injury. You can't comply. It's not that you don't want to, you just can't.
And what do we know about officer training with respect to mental health and injury cases where somebody might or might not be able to respond normally?
So officers get training before they are released with the badge and gun. However, they get it's either 4 or 8 hours of what's called de-escalation training, which is very important because that's training that they're going to use. That's here, yeah. And I think there are national standards on this too. But there's also just lawyers, like we take contracts and torts in law school. But 20, 30 years down the line, the laws change, and you need to follow up with continuing legal education.
And they get to pick what
They do.
they take, which is something that I think is important, because some things, some might say, should be mandatory, but they literally get to pick what classes they actually get to take. Some can take obscure classes, some can take core classes.
Right. And the mental health, we can do a whole podcast just about that and
Right.
how police deal with it. I think
But it's changing in Houston, I think, a little bit.
yes and no. I think there's a mental health epidemic in America, right? We finally recognize it, probably us growing up in the 80s and maybe 70s. We didn't know it. You saw somebody acting crazy, but you just said, hey, and I think there's an interesting statistic, and again, I don't want to go too much into this, the number of beds that were replaced from mental hospitals and mental institutions in the 70s. If you've watched One Flew Over the Cuckoo's Nest, we know that movie with Jack Nicholson. Those beds were replaced, and in the 80s and the 90s, replaced on this tough on crime with the number of prison beds, right? It was basically one for one. So in many ways, the criminal justice system is really a mental health system. And the police officers have to come in and, yeah, you're right. They don't have the training to deal with, there's other statistics, like they say 1 out of 3, 1 out of 4 Americans has some form of mental health, mainly depression, but something else. So 1 out of 4 people on the street are not necessarily dealing as a rational person because of their mental health.
And the officers take that
Right.
to mean that you're being, quote, non-compliant.
Right.
Oftentimes. So that's,
Yeah, no, of course. We've seen that. I think, like the George Floyd case you mentioned, right? He was crying out for help and couldn't breathe. Maybe he was having some sort of episode. There are some allegations of having drugs in the system and so forth. And that's where it comes in. The unsaid thing that's right in front of you is, how are the cops going to react when, a white man does something, or a white woman does something, or a black man does something, or a black woman, or a Muslim man or something. And that really plays into that. Is there a policy that says treat this race differently, or is there just the training? And a lot of it is coming out through one of the other things, in addition to mental health, is subconscious biases that every people have, and especially law enforcement can have.
well, I mean, more similar to than policy. They can have a custom or usage or a culture
Right.
of
Yes.
a particular way to act towards a certain group or
Right.
in a certain situation.
Exactly.
And I think one myth might be that law enforcement, in theory, is there to serve and protect. I think that's the goal, but have we seen some changes in that recently?
It depends on the facts of every particular case. And that is probably one of my biggest issues with civil rights law, is that no matter how great the facts look, it can be unpredictable what's actually going to happen. And you can have cases that have facts that you look at and you don't think they're that bad, and that might win the day. And then you have cases where folks may be killed and you say, this is a pretty obvious case of excessive force, yada, yada. But for some other legal reason, you don't win the day. And so there's just never been a clear standard that we can point to and say, hey, like, for example, if you have a contract with somebody and it's related to real estate and it's formed in the state of Texas, it's pretty clear it has to be in writing. You don't have it in writing, you can predict if someone tries to enforce the contract, they're going to have a hard time doing it. You can actually go out on the limb and say they're probably going to lose that case. Not so in civil rights cases. Every circuit is totally different. They interpret passive resistance, active resistance in completely different ways, and then they change their internal interpretations. The Supreme Court sometimes will step in and say, this is a standard that you need to apply totality of the circumstances and don't create your own standard. But those landmark civil rights cases coming from, I guess, the Supreme Court, those have become more few and far between. Okay, I feel like in most circuits, the judges are going to be pro law enforcement to an extent, depending on the circuit. But as you go higher up, it's even more pro law enforcement.
And we all believe that law enforcement, as a general rule, is a good for society. And I know personally some solid law enforcement officers and some folks out there that are putting their life on the line to make sure everybody gets to where they're going in a safe way. And I think, however, could do a better job, couldn't we, of maybe incentivizing officers in some way? And what the answer is got to be out there.
Yeah.
What do you think about that?
No, I mean, I worked in law enforcement, briefly state law enforcement. I was at the AG's office. So I got a different perspective. I'm on private practice. I'm on this side representing private citizens who get injured by state actors on civil rights cases. But that was interesting to be on the other side. And briefly had spent some time in college, internship in federal law enforcement.
What was your impression without saying
No, look, I'll tell you, I'll never forget. When Uvalde, Texas happened, the shooting there, we were all in the car, all law enforcement. We get a call from there. The tears, we were crying, grown men, when we were hearing what was happening. And I think, and again, just to your point about law enforcement, right? Like, yeah, there are the sacrifices that cops make on a daily basis. We don't even know how much they do to serve and protect. But one thing that we really, I saw was that the good cops are more upset at the bad cops who don't follow the law.
And there are more good than bad.
Yeah, 100%. And so I think that's important that the law should basically be helping the good cops do their jobs and should be stopping the bad cops, just like the reality is, right? If a good lawyer does something, you want to make sure that they're protected, right? But if it's a bad lawyer stealing money from their clients, you're not responding. The bar should come down and crack down on it.
And what stands in the thing that helps that along are these civil rights cases, which stand as a stark reminder to do what you're supposed to do.
That's right.
Yeah, really. And so when you're looking at, say, what the public believes, and I've had to explain this often, if somebody does something as a private citizen, there's one set of rules. If somebody does something under color of law, and I think we can probably go with the concept that if you're generally in the course and scope of your employment with law enforcement as you're doing something, of course there's exceptions, and of course there's a lot of law on this under the color of the law. That's one thing, but another set of rules actually applies, because what people ask me is, well, why can't they be held to a standard of negligence, right? Using ordinary care. Is there a standard of ordinary care in these civil rights cases or not?
Under state law, yes, you can definitely pursue damages against law enforcement under state law. Only problem with that is most states are going to cap you at a certain amount as to what you can recover. There are no caps if you can establish certain things under a 1983 case.
And let's talk about the basic requirements and help the folks understand a little bit what the difference is, because what I get is if they didn't do what they're supposed to do, and because the concept is if you don't do what you're supposed to do in your normal job, or if you make a mistake, or if you're just not doing right, that's one thing. But here, the standard is a little bit different. You have to be under color of the law, and then you have to show that there's a right that was violated, and there's different ones. Well,
established.
For
Right.
qualified immunity, that's separate. And then what's the next step? You have to show that there was some violation, excessive use of force.
Yeah. So that the force used was clearly excessive to the need. Meaning there is a degree of force that may be considered reasonable, but
it's a continuum.
It's a continuum for sure, but it's clearly excessive to the need, and you have to show no reasonable officer would have done that. And that's the standard. That's what differs from if they didn't live up to the standard and they fell below. That's more of a negligent standard. But showing that you have a clearly established the force was clearly excessive to the need, and no reasonable officer would have employed that force. It's almost like a fraud standard.
It's a higher level of proof.
Oh yeah. It's unless you have video, I would say, video, pictures, something that is irrefutable proof of what happened. It's going to be a tough standard to meet if it's just a he said, she said.
They have to be subjectively aware that their use of force was clearly excessive.
Subjectively.
So do y'all want to talk about how to litigate? Do y'all have experience with both of your firms?
Sure.
Alan, you're a trial lawyer as well. I've been doing it for many years. And George, let's talk about litigating these cases. Like, how do you start from the very beginning because you know it's going to be a long ride. So let's talk a little bit about you look at the right type of case. So that's important, right? Because we do get calls on all sorts of cases. This morning we had a call. You know, you pick the right type of case because you know that whichever case you have, you're going to be with that client for maybe 5 years or 8 years.
I mean, you have to decide where you're going to put the case. If you're going to go with a state claim, that's a set of rules. That's different than what we're talking about today. Today, we're talking about the constitutional violations, which will normally be with the United States Constitution that will normally be filed in federal court.
Okay.
And so you start with the complaint, and you have to walk through the different standards and the different proof, and you have to tie the facts to that. And then, of course, the other side has to go through line by line and identify the facts, and they have the opportunity to accept, reject, or comment on those.
Yeah. So the way I do it, you've got the facts, what happened. Most clients are going to be very familiar with those. Then you have liability. That's going to have its own analysis.
Responsibility.
Yep. And then you're going to have damages, which is a whole nother area. Thinking about the facts and collecting all the facts, that can be very time consuming, right? But that has to be done if you're going to triage the case.
Especially considering, I might have to just interject right here, that a lot of these cases, because at least in our jurisdiction, there is an internal affairs organization rather than a third party or an ombudsman, it is the fox guarding the hen house for the most part, right? And so is it easy or difficult to get facts soon after something happens, or do you often see that there's a pending investigation, we can't release this information?
Right. We're in the state of Texas, right? We're talking about state police, either DPS or Harris County sheriffs or Harris County, and all the different law enforcement. So let's talk a little bit about this. So we'll just break it up. So the complaint is obviously very important. How you make the facts, that's the first thing you do to get into federal court. So let's just take two steps back. Client calls you, says, hey, my family member was killed, police officer beat them to death. They were either in custody or some sort of stop. Let's take through what would you do at that stage? George, what would you do?
So take the facts in, right?
Yeah.
There's going to be a basic liability analysis, but then in a death case, the damages model is going to be different than in a case where there were 1 or 2 hospitals.
And the proof too, because the witness oftentimes will be the decedent, the person who suffered the loss of life themselves.
Right. So yeah, and exactly. So you have a death case, the real victim is dead. You can't talk to them unless they left something written down as they're dying, but again, that's not going to happen.
Right.
How do you do the investigation? So give us some tips on how you
So what I like to do is send what's called a public information request to the agency. And
Freedom of Information Act.
right. It's Texas's equivalent for the Federal Freedom of Information or FOIA request. And it's a request that is directed to the agency and gives the agency a specified amount of time to respond to all these requests for information. A lot of times, if it's under investigation, you will get that response. I think it's under investigation and you won't get much production, which that can be appealed to the state AG's office. Okay. And based on that decision, normally you're going to get at least an incident report at the very least. They made a custodial, in fact, in your death case, if they made a custodial death report, which they're required to do, you are entitled to that. So you're going to get that basic report. If there's other information, you can gain an awareness of what exists, even though you may not get it at that particular time. It may be later on before you get it, okay? But that's where I like to start my investigations in a civil rights context, because you want to make sure that all of the facts, especially in a death case that you've been given, a lot of those facts have been given to you by people who were not there. And you want to make sure that if there is a video or a cell phone photograph or something that will verify what happened on the ground, that you secure that really as soon as possible. Because again, the way the laws are written and the way the courts have interpreted doctrines like qualified immunity, clearly established rights, things like that, there are a lot of ways for the agencies, the law enforcement agency, to get your claim minimized or dismissed, or just dismissed outright. And it could turn on what happened on BWC, which is body worn camera. It could turn on a picture. So you want to verify all of that on the front end before you file the complaint. And complaints used to be very simple documents, 5 to 7 pages.
Longer
Back
now.
in the day, now they're like, I filed 50-page complaints.
Or more.
Almost written like appellate briefs because there might be an appeal.
And part of the problem too is you have a limited amount of chances to replead in federal court.
Yep.
And the thing here on the investigation, I think you guys mentioned, hit it on the head about getting the agency, getting their documents as soon as possible before
Right.
they get a chance to sort of create a story that fits the needs. What about talking to witnesses and talking to other people in the area? How do you recommend? Is that something that's helpful in building up this case?
So in a death case, you may not know who those folks are.
Yeah.
But if you do, definitely employing the services of a qualified private investigator, that can yield great results. You get somebody who's basically used to be in law enforcement to investigate what law enforcement
Well, what
is.
of social media? Like the whole George Floyd case, I think that really came into America's attention because we were all sitting at home during the pandemic, and a lot of that was different social media clips. I don't know if I don't think it was on Facebook Live or anything, but how does social media play into your investigation process?
It is an artifact in society today, and oftentimes it could be indispensable. And we are in the age of people being able to literally whip out their phone and take videos, and sometimes people will submit things or call for things or just post things on Instagram, TikTok, whatever. And sometimes information seeps through that way, which is rather quite helpful.
Yeah, and engagement on social media, that turns into clicks. Those clicks will turn into engagement. That engagement can turn into pressure on the agency
So that's another-
to start releasing information about the case.
So that reminds me, what about body cams? What has been your guys' experience with getting body cams from agencies you've been investigating? So
It's in my view, it's public information.
Yeah.
Law enforcement and the government exists for us. It is the government by and for the people. And I can't imagine that these law enforcement agencies have experienced as much success as they had so far in keeping that out of public view. What I think is important is transparency.
right.
And I've made requests to certain law enforcement agencies, and of late, what comes to mind is I was told it would be more than 200 days before they would release information after I paid for it, and that's a pretty long time, especially if you have statute of limitations running and things like that.
Yeah, and it's in the statute.
Right.
Video, they were real busy.
We got a lot of requests, and that's what comes to mind. I think we need to have some.
So what do you do there? Do you file the case and then issue a subpoena? The judge involved, or what do you do there?
You could. Another way to go, you could possibly do a 202 in state court.
Oh, 202.
Which is a mechanism by which you can request information under certain circumstances early, pre-suit,
Yep.
to help guide your decision whether or not you're going to sue ultimately in state court or in federal court. In my view, that's one way to do it, or you just keep pressure on the agency that you requested. And then I think really you could also file a suit under a FOIA request or under the public information request just for the information, because I think they have to produce the information.
And their mechanism that used to work. I mean, again, not to keep on bringing up the AG, but yeah, there is a whole division in the internal Attorney General's office that handles public information requests. It's Open Records Division. They have a really good, I'll just say they have a really good guide called the Open Government Handbook that every year gets updated with changes in law, decisions that have come out. Talks both about the Open Meetings Act and the Open Records Act, the Public Information Act stuff. That's a good starting point for a lot of this stuff. There's a lot of avenues. We don't know it here in Houston because we don't really litigate. In Austin, lawyers litigate PI issues all the time. In Houston, Wayne Dolcefino, if you know him, investigative reporter, he files suits. When Wayne Dolcefino sends a request to a law enforcement agency or any agency, we better believe that the response is coming properly because he's sued that many a time.
And got attorney fees.
And got attorney's
Yeah.
fees. You can get, there can also be criminal misconduct if a government official is purposely hiding information. There are criminal statutes, right? Now, you do run into the thing, if you're, let's say hypothetically, you're requesting from Harris County Sheriff's Office, the violation here, is the Harris County DA going to prosecute the sheriff official for not sharing information? I don't know. You have to think about that. But there are a lot of mechanisms. There are mechanisms to do declaratory judgments, right? So I think one thing that,
But there should just be more, in my view, Again, this is the government by the people and for the people. We are enough. We're the people, and we ought to be able to get the information from people that we employ through our taxes to do things for us. And I think there's this us and them mentality. And really, I think we should never lose sight of the fact that we are the ones that are making this happen. I mean, we create the laws, and they need to follow them as well.
I agree. I would almost say it might not be a bad idea. So in Texas, we just created and implemented a new court system, courts of chancery is what we called it back in the day. It's now the Texas Business Court. That's what we call it in Texas. And so they will handle matters of a certain subject matter and up to, I guess, you have to have a minimum of a certain amount of damages in play to qualify to be in the court. Maybe there needs to be a civil rights court.
I can see the arguments on both sides. Sometimes it's good to have something as narrow as that. But if somebody, it's hard not to develop opinions, even maybe strong opinions, if you're constantly seeing certain cases. I think I've always been highly respectful and amazed at the quality of the judiciary in jurisdictions where they have a full docket. You'll have a judge ruling on criminal cases, on family cases, on breach of contract, on negligence cases as well. So I think there's a lot of benefit in having that as well.
Yeah.
So that's a good question for, I think, the public or the legislature, if we think we should have a specific court. There's always been, now there's been drug court and there's been veterans court.
Yeah.
There's been
Juvenile court.
CPS has their own docket, mental health. And I think the judges in those courts would probably say, this streamline things, it's good. Like I say, there's also some benefit to having a court of general jurisdiction that hears things as well.
So if you have it in the federal side, and we talked about federal civil rights cases against state actors, and we had a whole topic on going up against federal actors under Bivens Act and all that. But if you go up against the government for certain claims, you have to go to the Federal Court of Claims, which is an entirely specialized court. They know their stuff. That body of law, they're experts on it. So you're not, because many times you get judges who maybe are judges and have been practicing, but not in that area of law, right? And you get a lot of. So I know that we're coming up to the end of it. What do you think, George? Let's talk about 1981 in another session.
Yeah, we can do that.
Okay. We gotta give a little bit of historical explanation. Yeah.
Yeah, so 1981 cases, those are cases, or it's a statute that you can use to sue a business if it has prevented you from enjoying the qualities and benefits of a contract, implied or actual, with that business that you had with the business. Good example, you go to a restaurant, the restaurant refuses to serve you, or they do serve you, then they tell you to get out, and you're like, why are you kicking me out? And they say, I don't like the fact that you're of color, so please leave. So
They
that's
might
it.
not say that. They might say, I don't like the hat you're wearing or something like that.
Yeah, unless it's a cowboy hat. Cowboy hats now have
Right,
some
right.
protection
Fair-
under
fair
Texas
enough.
law.
Well,
If you wear a baseball cap, they can throw you out. If you wear a cowboy hat,
That's
not
why I
so
have a
much.
baseball hat.
Yeah.
But yeah, no, I think this is so do we want to talk about it, or what do you want to do? Let's
We do it on the next one.
let's do it on the next
Yeah.
one. Yeah. But I think this was great. I think this was really, you guys have litigated these, you've done these cases, you've had success, you've had challenges also, and I think there are a lot of topics that we can talk about here.
Sure,
I would love
sure.
to get Allen, your wife, on this show.
Please.
Because this is the one area of law that we tell clients, there's only so much you can do, but you need to change the law. And
Right.
to lobby the government to change the law.
And I think that's real important. And with respect to these civil rights cases, most of the 1983 cases a lot of them being excessive use of force cases are really important, because I think it makes for better law enforcement, and I think it helps people, and it's a reminder that, hey, we are here and we have rights and we need to respect the Constitution.
Yeah,
Because
absolutely.
all the judges and the lawyers and everybody in charge has sworn an oath to the Constitution, and we need to have those reminders from time to time, because it's important. It is the law of the land.
We're not going anywhere. We're judging you. We're going to continue to judge you. So I'm George. This is guest Allen, our first inaugural guest. This is my law partner. We'll see you guys on the next episode.
Thank you.